All right. Hi, everybody. Thank you so much for joining us today. I'm Diana Farnes with the OU Intent programs. Intent is Innovation, Technology, and Entrepreneurship programs from the OU Innovation Hub down in Norman, although I'm based out of Tulsa, so we do have programming up in Tulsa as well. And today we have Brittany Littleton of Littleton Legal with us to talk about legal priorities when you're starting a new business. So thank you so much for joining us, Brittany. I appreciate having you here.
Thank you for having me. I'm excited to talk to you guys today. I see new admit messages come up, but Diana, if you could, will you admit those as we go? It's over my screen. It'll click stop share if I click on that button, just how it's lays. So, you ready for me to just jump into the presentation?
Yes, absolutely.
Okay. Well, I am talking today about legal priorities for new businesses. And I understand that some of you may be thinking about starting a business. Some of you may already have started a business. And so I'm going to, for those of you who have not yet started a business, this will probably be a lot of new information. For those of you that have, you probably have some of this information, but I think it's always a good idea to understand why you do certain things, and unless you have a legal background or just enjoy learning about the legal foundations, you probably don't know the specifics. So just a little bit about me. I am a business law and estate planning attorney based in Tulsa. My actual office is in Broken Arrow. I've been practicing law for almost 13 years now. And most days I think of myself first as a business owner and second as an attorney. I own my own law firm. I have a team of about 6 employees right now, and we're growing. And in my practice, I represent businesses pretty regularly through various stages of their operations. We help people set up new LLCs. We help businesses grow, and we help them exit. So regardless of where you are in your process, we've probably helped somebody like you. But I've also been on the other side of the fence. I grew up in a family of entrepreneurs. I've started non-legal businesses, and I took a brief break from a traditional law practice to act as the general counsel and COO of a startup company. And we merged that business with an established business. And so I went through the exit process, being on the side of the fence of the business owner as well. So the question that you're probably asking yourself is, what does it take to legally start and operate a new business? And I hope to answer that for you today. My experience with business owners and entrepreneurs is that they have great ideas and are super motivated to pursue them, but we tend to ignore the things that aren't in our strength zone. And I know for me personally, I am happy to delegate bookkeeping and things like that. I don't want to think about the things outside of my lane. So hopefully this will help you narrow down some things that you need to focus on so that you don't always have to be worried about it. At the beginning, it can feel overwhelming. If you're starting a Google search, you'll go down a rabbit hole, and there's a lot of moving pieces when you're starting a new business. That's definitely the startup life. But when it comes to the legal side of things, we can really think of legal priorities in 4 different categories. First, a goal would be to limit your personal liability, and that's typically done through incorporating or forming an LLC and also getting properly insured, and we'll talk more about that. Second, you're going to want to define your relationships with the people that you're doing business with or who are involved in your business. Third, you're going to want to protect your brand. And 4, you need to know what laws and regulations apply to you and how you can stay in compliance with them. So we're going to dive into each of these a little bit more in depth. So when should you formalize your business by incorporating? My recommendation is as soon as your business is more than a hobby, it's time to form an LLC. And until you do that, you're a sole proprietor who is operating your business individually. And so there's unlimited liability for any asset protection, creditor problems, personal risk. But when you operate your business as a company, your goal is to have limited liability. So what that means is that if you do it properly, you'll keep the assets that are in the LLC or the corporation separate from the assets that you own individually. Also, forming an LLC tends to give you heightened credibility. So when you're reaching out to partners and bankers and vendors, to be formally organized shows those third parties that you're really committed to this business and that you're taking steps to move it forward. So there's several options. If you do nothing and you're one person, you have a sole proprietorship. If you do nothing and you're more than one person, you have what's called a general partnership. And remember, those don't separate your personal liability from your business liability or your personal assets from your business assets. There's also limited liability partnerships, and that's where an investor is protected, but the operator has personal liability. And what's most common is the limited liability company. And it's very flexible. You can be taxed in multiple ways, and it's easy to set up and stay in compliance. Corporations are also used. This is when you would be an Inc. instead of an LLC. And if you're a company that's looking for venture capital or angel investors, typically they want to see you in a corporation because they want more uniform tax laws to apply. But for the vast majority of businesses, an LLC is our recommendation on how you would organize from the starting point. So for purposes of this conversation, I'm going to assume mostly that we're operating in an LLC, but just know that you could substitute the word corporation if that's how you were organized. So there's several things that are really low-hanging fruit for maintaining that limited liability protection. Because once you form the LLC, your protection is only as good as you're complying with the laws. So the first thing that you want to make sure that you do is never commingle your personal funds and your company funds. This means that you need to get a separate tax ID number, and we'll talk a little bit more about that in a minute, and have a separate bank account so that when revenue comes into your business, you're putting it in the business account. And when expenses are coming out, you're paying them from the business account and not your personal account. Often startup companies don't have revenue coming in yet, and your expenses are your personal contributions. But what you really should do in that situation is make sure that you are depositing the money that you're loaning or investing in the business into the bank account owned by your business, and then spend from there. You also want to maintain good corporate records. This means that beyond forming the entity with the Secretary of State, you're going to have up-to-date articles of organization that reflect where your principal place of business is. You're going to have an operating agreement, or in the case of a corporation, bylaws that are custom to how your business actually runs. And then you're going to, at a minimum, maintain annual minutes. And a lot of my clients' first instinct is to push back on why that's important, especially when they're a single member LLC, because it feels a little bit silly to say, yes, I'm the member, and yes, I'm the manager. And so obviously, if I make a decision I agree with that decision. But when you think about being a single member LLC, that shows a third party that you understand when you're wearing your manager hat and when you're wearing your member hat. And so that helps keep the liability separate. When we talk about minutes, to document them annually can be really simple. It can say, I've reviewed the financial records for the past year and I approve the actions that have been taken. You can also do special minutes for major things. If you were to admit a partner into the company or purchase real estate or something like that, that's worth documenting so that you show in real time that you're keeping records and going through those same formalities that a large business would go through as well. If you're partners, it's much more easy to understand why you need to document your agreement as you go. You never go into business with somebody assuming that it's not going to work out well, but you need the operating agreement as a backup plan for how the business would dissolve if you no longer wanted to move forward together. What are the rights and responsibilities of the members and managers? What limitations are there for each other, etc. Another thing that we see frequently overlooked is that business owners forget to conduct business in the company name. So anytime you enter into an agreement and the agreement is truly with your company, you want to sign the contracts not in your individual capacity, but in your capacity as manager. The party to agreement should not be your name, it should be the company name. You'd also want to register company assets in the company's name and not your individual name. Otherwise, it gets really tough to make the assertion that you deserve that asset protection. Sometimes for a new company, the party that you're contracting with wants it to be in your individual name because they don't want you to have that asset protection. And so you might need to personally guarantee something until you have established credit for your business and a good track record. But even if that's a requirement, you want to make that distinction. So we talked a little bit about a tax ID number. That you'll hear that called an EIN, which is a little bit confusing because that technically stands for employee identification number. But it's also referred to as a TIN, and they're used interchangeably. You can kind of think of an EIN or a TIN as your business's social security number. It is what uniquely identifies your business with the IRS and also with the state in which you're paying taxes. You need it to open bank accounts, apply for tax permits, and communicate to the IRS. If you're using an attorney to set up your LLC for you from the beginning, they typically will file the EIN for you as part of that process. But if you're bootstrapping it and not involving an attorney yet, you can apply for your EIN online for free at this website. If you go to apply your EIN and you Google apply for EIN, you're going to be careful that you're actually at the IRS website. There's lots of third-party sites that'll come up first that are trying to get money to do something that you can do on your own, and it's hard to get out of the cycle with them once you're in it. So let's talk about the LLC. I mentioned before that this is the most common vehicle to own a business because it's so flexible. And it can really be set up to have multiple tax purposes. So you can make it be a flow through or a disregarded entity. So that means that if you're a single member owner, it will, for tax purposes, the IRS disregards the fact that you have an LLC, so you don't have to have a separate tax return. You get the limited liability protection, but minimum tax administration complications. And you would file a Schedule C with your personal tax return that outlined your revenue and expenses. So that's typically the most simple and how a single member starts out. There's also partnerships, which are one or more than one member of the LLC, and that flows through to the individual partnerships and is documented in what's called a K-1. Often, as your business grows and your revenue has stabilized enough so that you're able to pay yourself an income that you would pay a third party if you were to hire them to be the manager of the company, it makes sense to make what's called an S Corp election. And in some instances, we make this election from the very beginning. But what this means is that your entity now files a separate tax return. You tend to save some on self-employment tax, but you have a little bit more administrative burden because you have to be on your company payroll. So you're definitely going to want to talk to your tax accountant about which tax status makes the most sense for you. The C Corp is almost never what we utilize. It just not for small businesses. There are certain exceptions to that, but I very rarely have clients that need to make the C Corp election. They're typically a partnership or disregarded single member entity, or as their revenue is stabilized, they're an S Corp. So beyond making sure that your LLC stays in order, you can protect yourself through business insurance. And there's lots of different types of business insurance. So I've listed them up on the screen just to give you an idea of things that you may need. However, it's really unlikely that you are going to need all of these from the beginning or be able to afford all of them from the beginning. But just thinking about, general liability insurance, that's what you would have to protect your building, protect people coming into your space. Products liability insurance, if you are creating a widget that could damage somebody if used improperly, or if you're a food-based company that could make somebody sick, often you have to have product liability insurance for a third party to carry your product. Workers' comp insurance is something that's required once you have employees. These down at the bottom are typically more optional, but definitely good ideas as you can afford them. Business interruption insurance is tied to typically a disability policy. And basically, if the owner of the company becomes disabled, it's an insurance policy that steps in to pay expenses because the business is losing your income stream during that disability period. And of course, you can have company benefits with employees, health, disability, life. That definitely is probably something that's on your wish list, not your immediate startup budget list, but can be a great way to attract employees. It can be a really good way for a business owner to convert after tax expenses to before tax expenses. For example, if you're buying your health insurance on the open marketplace, once you're able to buy group insurance for you and employees, your premiums are going to be less, and it's going to be something that your company can help pay the cost of. And then you can also own individual insurance the same way that you could without a business. So the next thing that you really need to make sure that you have a clear understanding of when we're talking about legal foundations is defining different business relationships. And a lot of times the terms that you see on the screen are used interchangeably incorrectly. So I just want to kind of go through this list and clarify what each of these words means in the context of their legal definition. So a member is somebody who owns interest in an LLC. And for a corporation, this is a shareholder. For an LLC, the interest is usually called membership units or membership interest. For shareholders, it's typically called stock. Managers, for purposes of an LLC, is not the same thing as a day-to-day manager. It's the person who's responsible for operating the corporate structure of the LLC. They're the person that has the authority to sign tax returns and enter into contracts on behalf of the company, make sure the operating agreement is enforced, etc. The correlation to a manager in a corporation is typically a board of directors, or sometimes they will just be officers, presidents, vice presidents, CEOs. Investors are somebody who's giving money to the business, and an investor can also be a member, but they might just be making a loan to the company. So it's really important to make sure that you understand when you're taking on capital or an investment of how that person is perceiving themselves in relation to the company. The other thing that's going to be really important to understand and distinguish from is employees and independent contractors. And a lot of times new businesses want to keep the people that are working with them as independent contractors because they perceive that to be less expensive. But once you get to a point where somebody has a regular schedule and a certain line of duties, they really become an employee. And if you continue to pay them as an independent contractor when they should be classified as an employee, you expose yourself as the business owner and the company to a lot of risk. Independent contractors are paid by 1099s, and employees receive a W-2 and are paid wages or a salary depending on their role. So we talked a little bit about what the different types of relationships are. These are the legal tools that define those relationships and lay out the agreement between the parties. So the operating agreement is the governing document for an LLC. I mentioned earlier that the equivalent for that in a corporation is the bylaws. And it talks about what the members can and can't do, what the managers can and can't do, any limitations. So for example, sometimes a partnership will have several partners, but really only one of them is doing the day-to-day management of the business. But they might include a limitation in their operating agreement that any expense in excess of $5,000 or wherever that threshold is for you must be approved by all the members. On the other hand, they might also say the manager has the authority to do all these things without needing to consult members. The buy-sell agreement is a document that established businesses want to look at to think about business succession planning. And it typically defines what will happen if your partner passes away, becomes incapacitated. You can make divorce or bankruptcy triggering events, all these things that could happen to an individual member that then have a huge impact on the other members and the company's ability to do business without court interference or without unintended partners that were inherited. You can define what happens upon that triggering event so that you agree on how a business succession plan would follow that triggering event. It's most often thought about in the context of what happens if a member dies, because their business interests could be tied up in probate, and that could slow down the manager's ability to operate the business since the member is now the estate of the deceased member. And then the person that inherits the estate might not be who you intended to have as your business partner. So it's very common for business owners to want to fund a buy-sell agreement, maybe with a company-owned life insurance policy that says, okay, I agree that if I die, that the company is going to own this life insurance proceeds and buy back my membership interest for this agreed amount, and then my estate will receive that instead of staying in the membership. We talked about investors and how they could look a lot of different ways. If you're taking money from anybody other than yourself, and actually it's good practice to even document this when you're making personal loans. You want to have a loan agreement. Often that's in the form of a promissory note, and if there's any security attached, a security agreement or a mortgage, or if an investor is paying money into the company in exchange for membership interest, you need to have an equity purchase agreement that can, if the agreement is between member and member, it's often a membership interest purchase agreement. If it's between new member and company, it can be a subscription agreement. How it's structured has different implications. So when you're negotiating the terms of taking on an investor, you want to make sure that you're getting good advice on how the deal is structured. Another business tool, a legal tool that we use for business owners frequently is called an NDA, or a non-disclosure agreement. And this is a document where you ask a third party to say that they will not share your business plan or information. So it can be really important if you have a new idea and you're pitching it to investors, or you are bringing in contractors that are helping you get the moving pieces in place, to have a non-disclosure agreement or a non-disclosure clause in the contract between you, to make sure that your company secrets are defined as company secrets and they can't take your idea and use it for their own benefit. So the next thing that you should be aware of is protecting your brand. And it happens all too often that we have a great idea, but sometimes that idea is subconsciously or consciously inspired by somebody's similar idea. Sometimes it's just pure coincidence. So before you invest in marketing tools and website design and branding, you definitely want to research both your business name, and if you're selling a product, your product name. Also any logo or slogans that you want to attach to your business. I find it's really hard for business owners to slow down and do this first, because you're excited to have something that is a public display of your great idea and what you're doing. But it can cost a lot of money to have to go back and redo those things or relaunch your brand that could have been saved by just some basic research. You also need to make sure that if you're operating your business as anything other than your full LLC or corporation name, that you register your trade name with the Secretary of State. So for example, if I was Littleton Investments LLC, but I went by the name Littleton Coffee Shop for the coffee shop that I was opening. I would have to make sure that I registered the name Littleton Coffee Shop to tie it to my LLC. And it's a really simple, it costs $25 to file a trade name report with the Secretary of State. I even file one. I'm Littleton Legal PLLC, but we're frequently referred to as Littleton Legal in our blogs or social media or things like that. So I have a trade name filed just for Littleton Legal so that nobody could make the claim that when I'm holding my business out publicly without the PLLC attached to it, that I'm not asking for creditor protection. You also should consider whether it makes sense to register your trademark locally. And if you're doing that on the state level, that is through the Secretary of State office, or if you should do it nationally, and that would be through the USPTO office. The distinction really is what it caused, or whether you need to do this. You're asking yourself the question, would it damage my business or confuse consumers if somebody else had a similarly named business or a similar confusing logo? And if you never have any intentions of doing your business outside of the state, maybe you're opening a restaurant, and don't plan to have more than one location, then you just need to register your trademark probably at the state level. But know that that's not a very thorough process to get that approved. So you still would want to do some research to make sure that you weren't violating a federal trademark. If you plan to franchise your restaurants and you're going to be crossing state lines, then you really need to think about registering your trademark on the national level. And this might seem obvious, but you need to make sure that websites are available and social media accounts are available, especially in today's very digital marketing driven world. It might change your company name if all the related websites are taken. That might be a clue that there's similarly named and similarly positioned companies or products. But also it just might make it harder for you to reach your audiences if you don't have a convenient way for them to find information about you. And there are bots and companies that are bad actors that can tell that certain names or websites are being searched, and they go in and they buy them up so that then you have to purchase the website from them. So the fourth thing is to really understand that your business is governed not only by the business agreements that you put into place with your partners or with third parties, but also you're subject to state and federal laws, regulations, and guidelines. And so I want to distinguish between these three things because they're not always obvious to everybody and can be confusing. So a law means that Congress has passed an act. Some examples of these, and I've used the food industry because I think it's one of the simplest ones to understand, are these laws. But these laws are broad and have a lot of different arms to them. And so Congress will delegate to an agency to implement regulations that talk about how a law is going to be interpreted and enforced. And so if there's an applicable regulation, it's binding on the industry, and you must follow the procedures once they're laid out. Often agencies, when a new law happens, will have a window of public notice and comment where they're saying, here's the specific procedures that we're laying out, and this is how we plan to interpret this law and enforce this law. If you are in a heavily regulated industry, you definitely want to pay attention to this process. It's going to give you a heads up on changes that might be coming that will affect how you do business. And it also gives you the chance to have a voice in how the regulation is defined. A good example of this is the medical marijuana laws that passed in Oklahoma. You know, the law was passed by people who were kind of dealing with a little bit of a Wild West situation. They might not have fully understood the implications and some of the logistical concerns. And so then it gets pushed down to the agencies responsible for enforcing it, who are able to say, okay, industry, here's what we plan to do. And there's basically a blank slate. And as the regulations become official, it impacts how the business has to be operated. On the food front, the FDA and the Department of Health are two very common regulating agencies that you'd have to comply with their rules. The last thing is policy statements and guidelines. And so this is typically non-binding, but it is guidance to help you understand how the agency will interpret a law. It is typically used to prepare businesses for changes or to give best practices. So you want to pay attention to those and think about them as you're determining how to operate your business, if your processes need to change, if you need to pivot. So it's really important that you understand what laws and regulations apply to you. So you'll want to be thinking about federal and state law, county laws such as the health department, and then any city codes. Often there are rules about what types of businesses can be in what areas of the city, how something is zoned, etc. Construction permits. It's better to know on the front end and do the research to define the scope of things that you're going to have to comply with, because there could be hidden cost and hoops to jump through that will significantly impact your business plan. So we've talked a lot about the four areas that I think are the most important business foundations. Just to recap, this is when a lawyer can help you if you have the funds available and or have limited funds and are trying to prioritize how you spend the part of your budget allocated for legal assistance. So step one is getting organized. You know, determine whether you need to be an LLC yet. If you are an LLC, are you a partnership? How are you going to define the relationship with your partners or investors? And are you taking basic steps to separate your personal and business assets and liability? If you don't have a good understanding of the laws in your field, to have somebody help lay out regulatory compliance for your business would be extremely helpful and a good use of any dollars that you can allocate to that. And then protecting your brand and intellectual property. You want to make sure that your business secrets are safe, that anything that's proprietary is protected, and that if you intend to have a national presence or a state presence that you want to be protected, that you're thinking through whether a trademark should be filed and when. And also ensuring that you're not violating someone else's trademark. Beyond that, as your business grows, I just want to point out some things that might flag in your brain. Here's when I might want to contact a lawyer. I tell my business clients, and I believe this to be true, that the more that you work with your business attorney, the less expensive it is to work with your business attorney, because they have the opportunity to really know what motivates you and learn about your industry and your business and be proactive in helping you mitigate your risk as you go. It's always less expensive to protect yourself on the front end than it is to deal with litigation on the back end. So if you're signing a contract, you need to understand that that legally obligates you and or your business. And so you want to make sure that you're being treated fairly and you understand what you're agreeing to. And I've listed some examples of contracts. Sometimes they'll have the word agreement and people don't realize that they can be sued if they're in violation of it, or when they might be able to sue the person that's not holding up their end of the bargain. Often an attorney can review a contract in an hour or two and just make sure that you know the highlights of it, or point out anything that's inconsistent with industry standards. They can also draft it from the beginning for you based on what you're trying to accomplish, and even help you negotiate it. As your business grows and you're adding employees, you want to talk to an attorney about making sure you're compliant with payroll laws. You want to have a good employee handbook and document policies and procedures. If you have employees and somebody files a complaint against you or is injured on the job, there are timelines associated with how you can respond and how you should respond. And so the sooner that you can have legal guidance, the better. As your business grows, think about how you are bringing in your partners and investors or applying for lines of credit from a bank. You have a lot of options in how you fund and expand your business. And a lawyer can help you understand what's best for you and your company and kind of lay out the pros and cons of different alternatives, and also help you negotiate a good deal or a fair deal. If you're ever sued, or you need to sue somebody, especially when you are sued, there is a tight timeline in which you must make an entry of appearance and initial response. And so having a lawyer lined up and in your pocket on the front end will help you be proactive in that. And if you need to sue somebody, there's what's called statute of limitations, and also regulations that might limit or define timelines. So for example, there's a separate timeline for a verbal agreement than there is for a written agreement. If you're wanting to file a mechanics lien or a materialman's lien, there's a very limited window that's days, not years, and certain processes that you must follow. And then as your business has developed and you're thinking about exiting the company, you want to document how your legacy will continue, how your business will be able to thrive, or if that's even what you want. You can sell your business, you can pass on your business, you can bring in key employees that become owners, and if your business just wasn't successful and needed to close down, there are certain loose ends that you want to tie up to close the door on any liability or reporting requirements as well. Okay, I feel like I talked a whole lot. Does anybody have any questions that they'd like me to cover?
I see that Ashley asked one in the chat. Ashley, do you want to ask your question?
Hello. I was doing some researching on kind of a concept that came to mind, and only to find out that it had been trademarked at one point, but as of June 2020, it was marked as abandoned, and everything I could find, it was like some agency in Arizona that was using it. And even then, it was a website page with a contact form.
Mhm.
So the question I've got is, what are some considerations? Because I really like the name, like really like the naming of the concept.
Mhm.
That I should consider as to, what does it take if you do take over a trademark like that? Or is it worth doing it or coming up with something else? And what are the potential things I don't know about all of that?
Right. So when you register a trade name federally, you have two options. You can essentially reserve a name that you intend to go into business because you're being proactive on the front end, or you can go ahead and ask for a trademark to be approved on an existing name. So when you reserve the name, there's a limited window in which you have to prove that you're using that in regular commerce. That might be having a product with the logo on it, or your established services. If somebody does not complete the trademark, the proof that they're in business within the window, then that's deemed abandoned, and it kind of goes back into the pot of availability. Trademarks have to be re-registered or renewed periodically. And if somebody doesn't do that, then the trademark becomes what's called dead instead of active. And then those also kind of go back into the pot. When you're thinking about trademarks, though, you also want to look at what's legally protected and legally available, and also what makes common sense. So just because you might win a dispute, if there's something that is a real threat, then you probably want to consider looking for something else. If it's something that doesn't have an active presence, then your risk might be super minimal. When we file a trade mark for clients, our first step in the process is to prepare a very broad or a very comprehensive report on anything existing that might be conflicting or confusing, either because it's registered or because it's active somewhere else but not registered. And so as you're thinking about that process, we break it up and say, let's do this report first, understand what we're working with, and then let's go through the application process. The filing fees for a state trademark are $50. It's several $100s for federal trademarks. And so it's a big investment to not have a pretty good understanding that it's likely to be approved. Does that answer your question?
Yeah, and the other thing is, like, I guess definitely making sure that until it is to a point where it is worth that investment, either using it, because I know, doesn't it go back to like the date of where you can document first use for that?
Yeah.
Okay.
Yeah, and so, you can establish what's called a common law trademark. It's much harder to defend in a lawsuit, but that's what you would also be looking for in a more comprehensive report. So let's say that there is a very established business, and let's use, for example, Goldie's hamburgers. If Goldie's has never filed a trademark and somebody opens Golden's and has a similar logo and a confusing name, Goldie's could probably make the argument that Golden's is too similar and that their brand is known enough that they have established what's called a common law trademark, and that it's unfair or against public policy to allow somebody to have a similar name that would confuse consumers.
Okay, thank you.
Any other questions?
I have a question.
Okay.
All right, so this is Rocky. Thanks, Brittany, for the presentation today. It was really great. Enjoyed listening to your slide, your information. It was great. My question has to deal with the operating agreement and expelling a partner or member. In that scenario, if the operating agreement explains that a member would be expelled via majority rule, what happens in that case as far as, is there something the member needs to sign to exit? And then how does it, for accounting purposes, the ownership that's been expelled, how does that get distributed?
So I'm going to give you a very unsatisfactory lawyer answer. It depends.
Right.
Your operating agreement is what's going to be the baseline for determining how that is navigated. Hopefully there are rules that say this is when a member can be expelled, but those are typically very narrow. And I would probably recommend it in most situations that a company is going to be better protected by going through negotiating an exit versus formally expelling somebody. And if your operating agreement doesn't have detailed explanation, then how it will be followed would be governed by statute. And if the statute is unclear, then and it is disputed legally, case law would be applied to look at similar facts and say this is how it's applied in this situation versus that situation. From a accounting perspective, you know, if you're a partnership, there will be K1s distributed. In a year where the membership allocation changes, there'll be one set of K1s from January 1st or the first date of your fiscal year and the point of separation, and then another set from the point of separation to the end of the year or the end of your fiscal year.
Okay.
So when it's convenient, we try to, for accounting purposes, structure deals to close 12/31 so that it's clean, it's simpler for tax purposes, but it's not a huge deal to have that kind of bifurcated tax return.
Excellent. Well, thank you.
I have a question.
Yeah.
Hi, Brittany. Thank you so much for that presentation. My company is Avis Precision Diagnostics Corp. We're C Corp. We're registered as a C Corp in Delaware, but we have the authority, or we have a certificate of authority to operate in Oklahoma. So I think that side of my business is great. I have two questions actually. The first of them is related to the doing business as. So my official legal entity's name is Avis Precision Diagnostics Corp. But what I've seen, at least off late when I've been marketing my company more as Avis Precision RX because my product's name is Precision RX. So what is the exact procedure of going about setting up a DBA? And how would a startup go about that?
So you probably would want to register that trade name both in the state where you're organized and where you're registered to do business. And from the Secretary of State website, there's a trade name report.
Okay.
Kind of just follow the questions.
Okay, perfect. That makes sense. Just writing that down, I'm sorry. Okay,
if you run into any problems on that questionnaire, my email is on the screen and you can shoot me an email. I'd be happy to.
I'm going to just quickly note that down as well. Thank you so much. My next question is related to actually taking or resigning members from the board. So my current board has 5 members, and I've talked to 2 of the board members that no longer want to be a part of the board, so it's a unanimous consent. I want to take off 2 members from my board and just make way, just basically streamline, just the operations and just the whole board meetings and all that stuff. Is it legally correct, or can I remove 2 board members from the board in the same board meeting, or as a part of the same board resolution, or would that have to come as 2 different board consents that are then signed, one after the other?
So it depends on how your board meetings are governed and
Okay.
what the terms of board of the directors are, depends on what's stated in your bylaws.
I see.
I would probably say that I mean, if everybody consents, there's not a problem to the resignation happening.
No, absolutely. Yeah.
But I would probably and if somebody resigns, you can't force them to stay a board member either. But I would probably say that the best practice would be to vote in 2 separate resolutions with the 2 individuals. They could be set up, the conversation could be set up on the front end to address the entire situation, but I would vote individually to have the record.
That does make sense. That's actually what my thought process was like, but it's good to hear the confirmation from a lawyer as well, because one of the more board members that wants to resign from the board, he is not a majority stakeholder. So I'm assuming in that case it could just be a majority consent amongst the 4 majority stakeholders to take him off the board. But the other one that wants to get off the board is a majority stakeholder. So in that case, it would have to be a unanimous consent where we get all signatures to then execute that officially. Is that correct?
Depends on what your bylaws say. So sometimes bylaws say this set of decisions has to have unanimous consent.
Okay.
This set of decisions has to have majority, a simple majority, and this set might have to have a super majority.
So reference to my bylaws, I think that's one thing I haven't done. Okay, perfect.
Whenever you can get unanimous consent, though, I mean, that's best.
Exactly.
Because then you don't have to worry about the person who is not consenting claiming that anybody's breaching duties or they've been treated improperly or.
Correct, of course. Perfect. No, that makes sense, Brittany. Thank you for your email too. I've written that down. I hope I can just shoot maybe just any questions, if I think of them later.
Yeah.
Thank you. Appreciate it.
Any other questions? If not, I'm going to stop share on my screen. Is that okay, Diana?
Yeah, that's great.
And now this moved over to my other screen. I gotta. Thank you guys for giving me the time to talk today and listening. I appreciate your questions. If you have any feedback for me, I give a variation of this presentation pretty regularly to different organizations. So if there's something that was really confusing to you or that you would have liked to see me spend more time on or presented differently, I don't mind helpful feedback.
And thank you so much, everybody, for attending. We really, really appreciate this.
My pleasure. Thank you for having me.
I did just think of one more question. Is there a certain, I don't know, income's not the right word, but a certain threshold of money that the business should be making before you look to maybe looking from the sole proprietor to the LLC?
So
if you're just starting out,
that's also going to depend on your personal situation and your industry. it's definitely going to be something you want to be consulting with your accountant on. What often happens is that you are in the single member status, and then after a completed tax year, it's clear that it would have been more beneficial, or if your business continues to grow, to make the S Corp election. But you have to be you have to be able to pay yourself a reasonable amount for somebody who you would hire to be in that role. And, that's subjective. And so your accountant can give you good guidance on that. The thing to think about, though, is that you can make an S Corp election within the a limited window when you file your entity, or within a limited window at the beginning of each tax year. And so what can be problematic is often that limited window at the new tax year is closed before you file your tax return. So you can talk to your accountant about possibly filing one out of time. And if it's approved, sometimes you can be treated one way through the first part of the year and another way for the remaining year. My advice too is to not lose a lot of sleep if in hindsight you might have saved some money on taxes if you'd have a different tax election, because that means your business is growing and that things are on track. And for every tax dollar you would have saved, it would also be offset by some administrative expenses. So you wouldn't want to incur that administrative expense before you were financially ready to incur it. So I just would kind of think about evaluating it annually.
Well, and even a step before that, the making the decision between okay, just getting started, sole proprietor, to, going LLC.
Yeah. So the businesses that I see starting as an S Corp right away tend to be forming an entity because they have a contract already. So they either know that their sales are going to be a certain amount, or maybe maybe they're a doctor or nurse practitioner or somebody that has a contract and is going to be paid a predictable amount each month as a contractor. They need to run it through their LLC, but they're not going to have a ton of business expenses. So it's going to be mostly profit, and so they know right away they'll be better off tax wise to treat it as themselves as an employee of the company receiving a salary.
Thank you.
Yeah.
All right. Thank you so much, everybody. Thank you so much, Brittany. I appreciate it.
Thank you.
All right. Y'all have a great day.
Bye.